Hello friends, welcome back to Jurist Lens. Today we are subject to discuss typical attributes of law. Dear friends, law has many attributes, which means in addition to its necessary features, law is characterized by many other characteristics. Now let us understand the typical attributes of law. Dear friends, there are 5 typical attributes of law. Number 1, law is linked with legal systems. Number 2, they are created by a recognizable person or body that has a power to make the law. Number 3, they are authoritative and authoritarian. Number 4, they are backed by regulated sanctions. And number 5, they receive obedience. Now let us see one by one. Number 1, law is linked with legal systems. Dear friends, Hans Kelsen states that a legal system is a unified order where every law gets its authority from a single ultimate source that is called as a grundnorm. Dear friends, grundnorm means it is the single ultimate rule or principle from which all other laws in a legal system get their validity and authority. Which means that it is not a written law like a constitution, but a fundamental presupposed command that says grundnorm means the historically first constitution or authority which ought to be obeyed. So the grundnorm validates the constitution, and based on the constitution we enact all other laws. Here all laws enacted under the constitution forms a legal system. This is how, according to Kelsen, law is linked with legal systems. Dear friends, a legal philosopher, Joseph Ross, says that every law necessarily belongs to a legal system. So according to him, a law is not isolated. Whether it is a single rule, command or a statute cannot be considered as a law in a meaningful sense if it exists in isolation. Now let us understand the Joseph Ross characterizing features of legal system. Number 1, legal systems are comprehensive and they claim to be supreme. Number 2, legal systems are open systems. And number 3, legal systems maintain and support other forms of social grouping. Number 1, legal systems are comprehensive and they claim to be supreme. Dear friends, Joseph Ross argues that legal systems are unique because they claim the supreme authority to regulate any and all type of behavior, so they form the legal systems. Hence the legal systems are comprehensive. But not all the laws form legal systems and claim supreme authority. For example, the sports clubs, companies, cultural organizations and political parties also have some laws. But those laws are not supreme because they regulate only the behavior of their own members and not universally applied. Moreover, these laws are not created by the sovereign. Therefore, legal systems are supreme over these rules. Hence, legal system can claim unlimited authority, no restrictions on the areas they can control. Number 2, legal systems are open systems. Dear friends, this feature is most obvious in the law of a territorial state. Remember, a state claims authority over all the behavior of persons, citizens and non-citizens within its territory and over all property situated within its territory. And even in many instances, over the behavior of its citizens out of its territory and over property outside its boundaries that belongs to a citizen. Hence, legal systems are not hidden. It is open that it can claim authority over persons and property within or outside its territory. Number 3, legal systems maintain and support other forms of social grouping. Dear friends, when we come to consider the rules of trade unions or sports clubs, it doesn't have a claiming authority to regulate any type of behavior in the society. Which means that sports clubs have their own rules about how to play a game or rules of workplace. But this doesn't cover murder, theft or taxation. Hence, the sports clubs does not have claiming authority to regulate other type of behaviors in the society as like the legal systems. Therefore, all these unions or clubs are maintained and supported by the legal system itself. Dear friends, second typical attribute of law is created by a recognizable person or body that has the power to make law. Dear friends, John Austin defined law as the general commands of a sovereign supported by the threat of sanctions. So every law made by the legislature is a particular authority and it is a recognized body by the constitution. Which means that this legislative can only frame the law because the legislative is the sovereign body that has a power to make law. Dear friends, on this approach, international law is not a law and doesn't form a legal system according to John Austin because it is not made by a particular authority or otherwise there is no single sovereign exist. Dear friends, HLA Hart declares that primitive law and international law are doubtful cases of law. He says international law lacks a legislature, states cannot be brought before international courts without their prior consent, and there is no centrally organized effective system of sanctions, which means no punishment for violation of international law. Then the law of a territorial state is very much law than the international law. This is the second most typical attribute of a law. Dear friends, third typical attribute of law is laws are authoritarian and authoritative. Dear friends, authoritarian means the legal enforcement authorities can claim authority over the behavior of the parties to the dispute and its decision shall be obeyed, hence laws are authoritarian. And this right to claim authority is not given to anyone else other than the legal enforcement authorities, hence laws are authoritative. Now let us understand this with a small example. A man, Alex, steals a wallet from a church donation box. Here, the church authority is limited, so the church as a social grouping can only impose internal sanctions like banning Alex from church. But the state's authority is not limited, it is supreme, so the legal system claims the supreme right to prosecute the act as theft. The state will investigate the case, arrest Alex against his will, put him on trial, and if found guilty, impose a penalty like a prison sentence or criminal fine. Dear friends, the state's claim of authority for theft is unlimited and absolute, overriding any internal rules or forgiveness that the church might offer, proving its supremacy over all other social spheres. Hence, laws are authoritative and authoritarian. But this attribute is not so well marked in international law. States can only be brought before an international court if they so consent. And there is no effective organized system of sanctions as far as international law is concerned. Dear friends, this is the third typical attribute of law. Dear friends, fourth typical attribute of law is regulated sanction. Dear friends, regulated sanction means that for failure to observe a legal rule, the court imposes some sanction or punishment and that will be enforced by persons appointed for that task. Now let's consider an example. Kavya drives her scooty in 120 km speed and is caught by a camera. This is exactly a breach of a traffic law. So the consequence is a fixed monetary fine and the sanction is precisely known in advance. So if Kavya refuses to pay, the court will send officially appointed government collectors to enforce the payment. Hence, violations of rules attracts punishment. So the fourth typical character of law is a sanction for violation of rule. Dear friends, fifth typical attribute of law is people regulate their behavior or law is obeyed. Dear friends, for John Austin, positive law is the command of a sovereign that is backed by a sanction. Here is another simple example illustrating how the law's command encourages compliance even among those who might not fully obey. Dear friends, here the sovereign commands that all citizens must file their annual income tax returns by a fixed deadline backed by the sanction of a fine and possible prosecution for evasion. Dear friends, most citizens obey the law completely, filing their taxes honestly on time. But a smaller group of people who might otherwise ignore the deadline entirely are still influenced by the law. Knowing the sanction exists, they will still file their return, perhaps only a few days late, merely to avoid the severe consequences. Hence, the sovereign's command backed by the threat of a sanction regulates the conduct of even the less than obedient members of society. So finally, people regulate their behavior by own or otherwise law is obeyed by them. Dear friends, now let us consider what is arbitration and its legal process. Dear friends, arbitration is a legal process when the agreement allows the arbitrator to issue a binding ruling on a contract dispute, meaning the decision is enforced by law. So this creates an institutionalized dispute resolution where the outcome is a definitive legal decision validated by the legal system. However, in other forms like wage negotiations between an employer and employees, the arbitrator only gives a recommendation because the parties are not legally required to accept this non-binding advice. It lacks the essential feature of a legal process. So in this arbitration, we see the total absence of the typical attributes of law. Number one, the arbitration is not really a part of system when it becomes regular and it is in danger of being turned into a legal process. Number two, the arbitration is not usually set up by a person or body with the power to create law. Usually, the parties to the dispute jointly decide on the method of arbitration and the person of the arbiter. Number 3, the arbitral body doesn't act as if it was authoritative and authoritarian. Failure to observe the recommendation doesn't result in a regulated sanction imposed by the arbiters and enforced by persons appointed to that task. So the recommendation is likely to be obeyed. Number 4, the key difference is that a declaratory action is a legal process brought before a court resulting in a proper authoritative judgment on legal rights even if it lacks immediate sanctions, while non-binding arbitration does not. Last one, and the absence of a sanction or a means of enforcing a decision in arbitration doesn't tell against the status of a legal process. In fact, the authority of the court is great enough to restrain illegal conduct.